Byron Donalds is a congressman from Florida. His votes help cops kill more innocent, unarmed blacks. And I'm not making that up. He admitted in a recent Breakfast Club interview he voted against the George Floyd Justice and Policing Act. The critical provision in that legislation is the abolishment of qualified immunity. In a few minutes, I'm going to explain what qualified immunity is and why it's so urgent. Another critical provision of the act is the requirement of data collection. That's critical because we don't really know how many cops are killing how many black people because it's underreported. And that's because jurisdictions across this country are not required to report such killings. That's unfortunate because there are over 18,000 police departments in America. In this video, I'm going to refute all the disinformation Byron Donalds disseminated in that Breakfast Club interview recently regarding qualified immunity. Let's get into it. Now, before we get started, please do several things. First, like, share, comment, subscribe, and click the bell so you'll get notified when we drop one of these powerful and informative videos. Second, if you have an African-American male in public school, go over to Amazon and grab a copy of my book, Education and Justice, where I tell you how public schools mistreat African-American boys and what you can do about it. All right, so go over there and grab your copy. All right, so let's get right into this. This is a very, very, very important topic. And quite frankly, you need to watch this video from start to finish. From start to finish, because I'm going to explain to you what qualified immunity is and why it's so important. And you're going to see how misleading the information that Byron Donalds gave in that Breakfast Club interview. Why is it important that we combat that type of disinformation? Because he's speaking to the youth, and he's trying to intentionally mislead the youth. And when it comes to qualified immunity and police reform, it's really important because, well, just think about the Sonia Massey killing recently. Those killings are very traumatic, and they speak to the fact that oftentimes we are the victims of government tyranny. So we need to be correctly informed about police brutality in excessive force cases. All right, so let's get into this. It's very important. Once again, please watch all the way to the end. Now, in front of you, there is a graph, and this graph shows, that blue box there shows that blacks are disproportionately killed by police officers. All right, disproportionately killed by police officers. We are, as a race, killed more often by police officers than any other group by far. That includes the Hispanic community, the white community, the Asian community, and so on. Now, don't think that we are more criminally prone than any other group. That is not the case. I'm going to show you why in just a moment, why African Americans are the targets of cops so often. Okay, let's go back to the other screen. And here it is. So when we talk about police brutality, we must talk about the legacy of racial oppression in this country. Let's start with chattel slavery. And if you do any study on policing in black communities, you will discover that policing actually started out in our community as slave patrols. And when you start that way, it's very difficult to correct things. And so many cops continue today to act like they are on slave patrols, just in the way they deal with us. So this whole thing for us started in chattel slavery. And then, of course, after slavery ended, we dealt with Jim Crow. And with Jim Crow, we saw black code laws, and namely, we saw the invention of the KKK. Many of them were former Confederate soldiers, and many of them became members of law enforcement agencies across the country. And so policing, again, continued to have that racial element in it. So first chattel slavery, Jim Crow, and then all of that produced fatherlessness in the African American community. And then what does that produce? That produced concentrated generational poverty in the African American community. Again, all of it related back to several centuries of chattel slavery, a century of Jim Crow, which produced, again, fatherlessness, which then produced poverty. And out of those conditions came crime. And because crime is disproportionately present in our communities, that brings about over-policing. So it's not that blacks have a criminal gene. It's not that we are criminally prone. It's that we have been the target of white supremacy in this country that has, in many ways, broke down important institutions in our community, again, like the family. And that has resulted in a lot of crime being committed in our community. But also there's a whole lot of racial profiling by police officers in our community. And don't forget, and it's really important that you understand, that despite this awful history, most African American people are law-abiding citizens. I never fail to mention that because we are stereotyped, again, to be seen as people who are criminally prone. That's what racist, white supremacist people want everybody to believe, but it is not true. Most blacks are law-abiding citizens. Get up every day, go and do the hard work for this country and pay their bills and so forth and so on. We're not represented by the young people oftentimes that we see in the streets misbehaving. No, we're more represented by the men who get up every day and go work hard for their families and bring the food back to the table. Those are the people who really represent us. All right, let's go back to the other screen. So all of that policing causes us to have a lot more police encounters and therefore cop killings than other communities. So you could put your finger on, say, fatherlessness and say that's the immediate cause of the poverty and the crime, and I would be okay with that. But the root cause is, again, 240 years of chattel slavery and 100 years of Jim Crow that we still today deal with as a people. All right? In fact, Jim Crow has been dismantled now in my lifetime, in the last 60, 70 years. All right? So let's move on. So how does qualified immunity works? Because qualified immunity is very much at the root of a lot of the cop killings in the black community of innocent, unarmed black men, to be specific. All right. And we can think of many examples. George Floyd, to name one, absolute first name that comes to mind. Right. And then there was Philando Castile, Tamir Rice, Walter Scott. I mean, I could go on and on and on. Here recently, Sonia Massey, Sandra Bland, Tatiana Jefferson, Breonna Taylor. Again, we could go on and on and on with people who were killed by the police who should be here today. Qualified immunity is at the root of a lot of these unjust cop killings of black people. Now, let me explain to you, let me give you a scenario of how qualified immunity works. And I'm very familiar with this scenario because I am a civil rights attorney and I litigate these cases. Chloe, my daughter, and I, we have cases now in federal court, holding police officers accountable. So this is what we do. We litigate these cases. We know the law behind these cases. We know the rules behind these cases. And so when I heard Byron Donalds on the Breakfast Club saying the things that he was saying about qualified immunity, I knew he was lying. I knew he was lying, and I'm going to show you. And it's important that you know that he was lying and that you are educated and informed on what qualified immunity is. But anyway, let's imagine a police officer shoots an unarmed, innocent black man in the back as that black man is running from an empty house, and the shot killed him. The man's family sues both the officer and the police department. We often sue both, the cop and the cop's employer. Now, let's say the district attorney gets a grand jury to indict the officer for murder, meaning the officer faces two different cases. He faces a criminal case and he faces a civil lawsuit, specifically a civil rights lawsuit. Now, in response to that lawsuit, the officer's lawyer or lawyers argue the case should be dismissed because of qualified immunity. Qualified immunity is a legal doctrine that shields government officials, including police officers, from liability for civil rights violations. So qualified immunity is a shield against civil liability when government officials, including police officers, violate the rights of citizens. All right, so there's more nuance to that definition that you're going to see in just a moment. All right, now, after months of litigation, back to my scenario, the officer's lawyer or lawyers asked the judge to dismiss the case based on qualified immunity. And guess what happens in so many of these cases? The judge agrees and dismisses the civil lawsuit. All right, the civil lawsuit. The case in the criminal court may proceed. And by the way, it is very, very difficult to get police officers indicted in the first place. Very hard, because police officers are seen as the good guys. They're seen as the good guys. So grand juries are very reluctant, and prosecutors are very reluctant to even try to present evidence to get a police officer indicted. But let's say in this scenario, the officer was indicted, so the criminal case continues. All right, and let's also say that the officer was found guilty in criminal court. But, as I said a moment ago, the judge dismissed his civil case. So how can that be? How can the officer be guilty in criminal court of killing that unarmed, innocent black man, but qualified immunity resulted in the case being dismissed? How do you end up with that situation? How does that work? Why does that happen? Well, I'm going to explain it to you, and I am emphasizing it because that just shows you how badly qualified immunity needs to be abolished. And it could have been abolished pursuant to the George Floyd Justice and Policing Act had the GOP not blocked it, including Byron Donalds. All right, so that brings me now to the interview that he gave at the Breakfast Club just a week or so ago. Go and watch that interview. I'm not going to play the video because I don't want iHeart, who owns the Breakfast Club, to strike my channel. But here is the transcript. Here are excerpts from the transcript. These are the words that came directly out of Byron Donalds' mouth. All right, so he says, the issue with, and by the way, Angela Rye did a great job of putting him on the record and making him admit to millions of people. I don't know how many people has watched that video now, but it's growing. I think it's at least 500,000 people. But she forced him to answer these questions and admit to the Breakfast Club audience that he voted against the George Floyd Justice and Policing Act. I don't know how he did that, because we all saw the lynching of Mr. Floyd. We saw it with our own eyes. And one of the reasons that cop Derek Chauvin was so brazen is because he knows, or he thought, that qualified immunity would shield him from civil liability. And he thought that he probably would not be indicted, but he was wrong. The family of George Floyd did get a civil settlement, and obviously Mr. Chauvin was found guilty, and he's serving prison time now for the murder of George Floyd. But that's the rare exception. That's the rare exception. It usually goes the other way. But anyway, Byron Donalds said this, quote, "The issue with qualified immunity is very simple. If you remove qualified immunity from policing, you're going to have less officers on the street. Police officers make what, $70,000, $80,000, $90,000 a year? They have, most law enforcement has about 40 million or more encounters every single year with citizens. If you remove qualified immunity, I'm telling you this will right now, because I've talked with law enforcement officers all across the country, not the chiefs." He goes on to say, and when you violate a constitutional right, qualified immunity doesn't apply to you. And that's what I'm talking about. It does not. And Angela, don't do that. So him and Angela are having a colloquy. They're going back and forward. So that's why he says that, because she disagreed with him. And he says, it does not. I thought that was the definition. I thought that was the definition. No, it does not. I thought that was the definition. No, it does not. So the transcript is again showing the back and forth that he's having with Angela Rye, who is doing her best to correct him. But of course, she has time restraints that I don't have in this video. So I can lay this out for you. And that's what I'm doing. So from what you just heard, Byron Donalds opposed the George Floyd Justice and Policing Act, which means he opposed the abolishment of qualified immunity for two main reasons. Number one, he argued that abolishing qualified immunity would cause police officers to stop working in inner city communities out of fear of losing their personal assets. Number two, he argued that qualified immunity isn't really necessary because judges will not dismiss cases if an officer violates a black person's constitutional right. So his arguments, those two arguments, are the reasons why he says that he voted against the George Floyd Justice and Policing Act. I'm going to show you that both arguments are erroneous. So let's go back to the first argument, that police officers will leave the departments that they work for, especially in inner city communities, out of fear that they will get sued every time they have some sort of encounter with black people. And then if they lose the lawsuit, they're going to have to use their personal assets to pay off the judgment or settlement. That's false. That is false. And you know why it's false? Because police officers have what is called indemnification. Indemnification. Now, what is indemnification? Think of indemnification as insurance. It's just that it's the type of insurance that they don't have to pay for. Their employer provides it. And we call it indemnification. They are indemnified. So if they end up being sued and a judgment comes out of that or settlement comes out of that, those officers do not have to pay that. Their employers will pay that civil judgment or settlement. So it is a false premise that police officers would be exposed to civil liability if you abolished qualified immunity. Abolishing qualified immunity does not remove the indemnification that the officers have because their employers provide that. And there is this huge study that found that in 99.9% of the cases, employers, the cops' employers, that is the government, the municipality, the city, whatever law enforcement agency they are working for, in 99.9% of the cases, that municipality or that law enforcement agency will pay that settlement or judgment. So the cop does not have to come out of his pocket if qualified immunity is abolished. Byron Donalds is wrong about that. And I want you to really understand that. All right? That is a false premise. So there would be no incentive for police officers to quit policing in the inner city community out of fear that their personal assets would be used to cover settlements and judgments if qualified immunity is abolished. All right, his second argument is also erroneous. Remember, his second argument is the fact that, or he argued that if you abolish qualified immunity, his second argument is that qualified immunity is really not needed because if a cop violates a black person's constitutional right, then the cop cannot use qualified immunity as a defense. He's wrong about that as well. And do keep in mind, Byron Donalds is not an attorney. He is a congressperson. He was a businessman before he came to Congress. This is not what he studies on a daily basis, like myself and other civil rights attorneys. So when he said what he said, I knew he was either intentionally trying to mislead the Breakfast Club audience, or he was mistaken. I believe it is disinformation, which means he was intentionally trying to mislead the Breakfast Club audience in saying that qualified immunity is really not that important because if a cop violates your constitutional right, then the judge will not dismiss the case. That is very wrong, and I'm going to prove it. And we need to understand that just because a cop violates someone's constitutional right does not mean that the judge is going to automatically not give that cop the benefit of qualified immunity. All right, let's go back to the screen and let me explain why I say this. So, Donald's second argument is flawed because both he and Charlemagne relied on an incorrect internet definition of qualified immunity. If you go watch that interview, you'll see that Charlemagne went online and found some definition of qualified immunity that was absolutely incorrect. But that definition did support Donald's position. So both Donald's and Charlemagne were incorrect about what qualified immunity is and how it works. Angela Rye was trying to tell him, but Donalds was over talking her. All right. So what is the definition that they found? Charlemagne found the definition that says qualified immunity protects government officials from civil lawsuits unless they clearly violate a constitutional right. That is not the definition of qualified immunity. That is not the way it works in the court system. And let me tell you this, and I need to look you in the eyes when I tell you this. This is why you hear me say so many times, don't take the words and the opinions of TV personalities and rappers and athletes and talk show hosts and comedians when it comes to legal things. You cannot go online and get some definition of some legal term or some legal doctrine and use that to build your argument. You can't do that for a couple of reasons. Number one, those legal definitions and doctrines are very nuanced, and they have been interpreted by judges in specific cases. And so you need to know what the case says that has interpreted that particular doctrine. When we are practicing law and we cite a case, that's the reason why we cite a case, to inform the judge what higher judges have said about that legal doctrine. We definitely don't go online to the internet and do a qualified immunity search and come up with some definition and put it in our motion or put it in our brief or put it in our complaint. No. We spend 3 years, after 4 years of undergrad, we spend 3 years in law school studying these cases. And then we practice for many more years. And so you can't do what I do based on doing some simple internet search. And that's where they went wrong. Charlemagne is not an attorney. Byron Donalds is not an attorney. Angela Rye is. That's why she kept saying that's patently false. But Byron Donalds wasn't listening. He just was trying to get his message out to the Breakfast Club audience. So, in order to understand legal doctrines, we have to go to the case law, where the judges, especially the United States Supreme Court, has interpreted, and they tell us what that doctrine means. All right, so remember, it is the U.S. Supreme Court that explains and interprets the Constitution, statutory laws, and other laws. We have to go to them to find out what they said about something, not the internet. And it takes skills to do that. They don't have those skills, and that's why what they said about qualified immunity, this definition they gave, was so incorrect and so misleading. All right, now let's go back. So again, Charlemagne came up with this definition: qualified immunity protects government officials from civil lawsuits unless they clearly violate a constitutional right. That sounds good, but it's not right. Now let me show you. Let's go to where we need to go to accurately define this term, and that is to case law. So now, what does case law say? All right, let me pull it on the screen. All right, it says qualified immunity includes 2 inquiries. The first question is whether the officer violated a constitutional right. The second question is whether the right at issue was clearly established at the time of the alleged offense. We can decide one question or both. All right, now, it is important that you see that there are 2 parts to the definition or the requirement of qualified immunity. The first is whether there was a violation of one's constitutional right. So that's what Charlemagne found. Was there a clear violation of a person's constitutional right? But the inquiry doesn't stop there. The second part of the inquiry requires to determine whether the right at issue was clearly established at the time of the alleged misconduct. So, was it clear? Was it clearly established that the right that was violated was a clearly established right? It's not enough just to show that the officer violated the constitutional right of the victim, but was that constitutional right clearly established at the time of the misconduct or at the time of the offense? See, that places the burden on the plaintiff to have to show not only was there a constitutional violation, but that constitutional right was clearly established. Once the defendant raises qualified immunity, the plaintiff must show that the officer violated a constitutional right of the plaintiff, and that constitutional right was clearly established. So then the question becomes, how do you establish or how do you prove that a constitutional right was clearly established? Well, it goes on to tell us. The second question, whether the officer violated clearly established law, is a doozy. So that shows right there, the Supreme Court says that is a heavy burden for the plaintiff to have to show. In other words, this is tilted against, qualified immunity is tilted against the plaintiff, the victim. I mean, the court admits it right there. That second element of proving that the constitutional right was clearly established is a heavy burden, a doozy, in the words of the court. Anyway, and the burden is heavy. A right is clearly established only if relevant precedent has placed the constitutional question beyond debate. So that means the plaintiff has to show that there is case precedence, that what the officer did was in violation of a clear or clearly established right. Again, that is a heavy burden. So I'm going to show you a couple of cases here in a moment to demonstrate why that's so heavy. But the analysis does not stop with whether or not a person's constitutional right has been violated when the officer is claiming defense under qualified immunity. That's not enough. And that's all that Charlemagne went online and showed. That's not enough. Byron Donalds completely misrepresented how qualified immunity works because he says it's really not that needed, because if the officer violates somebody's constitutional right, then the judge is not going to dismiss the case on the basis of qualified immunity. That's not true. The officer could have violated the victim's constitutional right and still get qualified immunity, because the second part requires that the plaintiff show that the constitutional right was clearly established. So if the officer does something that violates the constitutional right of the victim, the officer could simply say, I didn't know that that was a violation of the victim's rights. There's nothing that clearly established that that was a violation. How would I know? There are no cases to say that that was a violation of someone's constitutional right. I didn't know that. That hasn't been clearly established. And then if the officer does that and can, and the plaintiff is not able to show, no, judge, in response to the officer's argument, the plaintiff must be able to show, judge, no, here are cases with similar facts that show clearly that this constitutional right is protected. There is precedence here. So there's no way this officer would not have known that what he was doing was a clear violation of the constitutional rights of the victim. If the plaintiff is not able to do that, that officer gets his case dismissed pursuant to qualified immunity. So Byron Donalds lowered the standard of what qualified immunity requires. That's disinformation. And that's why I'm taking the time to show you that he was disinforming the Breakfast Club audience with that foolishness. Now, let's look at a couple of cases. So this case here, Cass versus City of Abilene. All right, let's go back to that screen. In Cass versus City of Abilene, police got a warrant to search a gold exchange store for a minor violation, supposedly in retaliation for Marcus Cass criticizing a policy they supported. In other words, the police was retaliating against this man, Marcus Cass, because he criticized something they liked. So they got a search warrant. And here's what happened. Instead of serving the warrant normally, the officers conducted a tactical raid. One officer, without clearly identifying himself, entered Cass's office with his gun drawn. Cass, thinking it was an armed intruder, pulled his own gun and he was shot. The officer shot him and he later died from his injuries. The Fifth Circuit, nonetheless, granted the officers qualified immunity. And here's why. When the officers raised qualified immunity as a defense, the burden shifted onto Mr. Cass's representatives to show that Mr. Cass's constitutional rights had been violated. But they also had to show that those rights had already been clearly established by providing some case precedents with similar facts. And the fact pattern in the Cass case is so unique, it would have been very difficult to provide cases with similar facts. They would have had to find a case where the officers were retaliating against a person who criticized them or held an opposing view on some policies, and instead of doing a regular search warrant, they did a tactical raid. They would have had to find a case that's not exactly on point, but pretty close, so that they could say, no, Your Honor, that happened, the same fact pattern or similar fact pattern happened in such and such case, and again in such and such case, and it was clearly established that that behavior was unconstitutional. If they couldn't find cases like that, the judge would have been duty-bound to dismiss the case based on qualified immunity. That's why the court said this is a heavy burden. They admitted the qualified immunity standard that they created is very, very, very biased for police officers. And that's the reason why qualified immunity needs to go. It needs to go. And it's the reason why I say that Byron Donalds votes on this issue help cops murder more blacks with impunity or with immunity. Are you with me? All right. There's another case. Another example is Chloe v. Barron, where a police officer shot and paralyzed David Chloe, an innocent and unarmed black man who loosely matched the description of suspects in a nearby robbery. The officer shot him in the back as Chloe was pulling his hand from his pocket to show where he was going. Didn't have a gun, no weapon, wasn't intending on doing any harm to the officers, just to show them where he was going. Even though the Fifth Circuit called the case tragic, they still granted the officer qualified immunity because there was no clear legal precedent stating that the officer's actions were unconstitutional. All right? Qualified immunity is tilted heavily toward police officers. I can think of another case. It involved the city of Fresno, California. It's a real unusual case in that police officers served a warrant and they stole $200,000 of cash and rare coins from the person they served the warrant on. And the court still granted those officers qualified immunity, although they clearly broke the law. So again, this is tilted heavily toward police officers. And it's the reason, again, why qualified immunity must be abolished. So when Byron Donalds said that as long as someone's constitutional right is violated, that cop cannot get qualified immunity, that's erroneous. That's false. All right. So you can think of all kinds of examples where qualified immunity would get a police officer's case dismissed. And they know it. They know how difficult it is for people to get to find some sort of established precedent that shows that the cops' behavior was in violation of the victim's constitutional rights, and that right was clearly established. The cops know that. That's why they do the stuff they do. And then they also know that even if they are not given qualified immunity, they know what I told you earlier is they have indemnification. They know that they are indemnified and they're not going to lose their house. They're not going to lose their pension. They're not going to lose anything from their behavior because they have two things: qualified immunity and indemnification. And they're probably not going to be prosecuted in criminal court. And so as a result of that, cops kill a whole lot of black people. And so when Byron Donalds voted against the George Floyd Justice and Policing Act, his vote on that bill helped cops murder more blacks. Now, you know that Byron Donalds is definitely spreading disinformation. But I am hot on his track. Hot on his track. So from that interview so far, I have done 3 videos. One where he defends Trump's racism, another one where he voted against the John Lewis Voting Rights Advancement bill, and now this one where he voted against the George Floyd Justice and Policing Act because he did not want to see qualified immunity abolished. All right, I am Attorney Augustus Corbett, one half of the Defiant Lawyers. This is what we bring you on a weekly basis. Okay? Once again, like, share, comment, subscribe, click the bell so you'll get notified, and make sure to share this video with everybody so that we can refute all this disinformation that is being targeted to African American communities. All right? Until the next time, peace.